Even if it did hit 3 questions, which would be unprecedented, if you still knew everything else very well, you'd have your 5, and that's the worst case scenario. But it's so much work to learn all that stuff. I'm loath to say you can leave anything out. I'm just saying that you might decide to spend your time more efficiently elsewise. Examiner could set 4 questions on it. I can't control her. I don't know. And no one can pass the exams. That could happen, and I can't legislate for that. Okay. You have to be able to think of what's wrong with the law and is there any way it could be made better. Now, you don't throw that down in every question, but if you're asked to do it, you do it. On the 08 paper, the examiner asked something along the lines of, tell me about illegality in public policy. In what respect is this a dynamic area? Something along those lines. And she says in the report, look, a lot of people gave me a great essay, but a lot of people ignored the second part, that I'm not asking for the government my health. If I ask you to tell me if this is a dynamic area capable of flexing, you have to answer that. And some people just didn't. And that's coming, like I said before, more a feature on the exam. In what respects is this area in need of reform? Do you think the law is clear? Is the law capable of melding itself to new circumstances? If you don't answer those part of the questions, you don't get the marks. And all it requires is a bit of thought for every topic. Where are the defects? What could be done? Question. Is the contract vitiated by mistake? Examiner said you should consider mutual and unilateral mistake here, and then didn't mention one case on mutual mistake, and mentioned all the classic unilateral ones. There's no argument on mutual mistake here. There's not. Okay. But just if we had to analyse mutual mistake here, remember the idea was with mutual mistake, if an observer looking in would view a contract being in existence, so be it. And the undisclosed intention of one party doesn't change that. And what you're looking for to win a mutual mistake argument is the Mespel and Capaldi situation, where the words used by the parties are not capable of bearing one objective meaning. Whereas on this case, reasonable observer looking in on the machine and the orders will see advertise 1599, email 1599, acceptance of flight. There's no mutual mistake argument here. I'd bet my house on it. You can't make it out. But unilateral mistake, on the other hand. Remember, unilateral mistake is where one party makes a mistake entering into a contract and the other party knows about that or ought to know about that. So there would be an argument that the contract might be vitiated by mistake if Air Dublin made a mistake entering into the contract and Paddy in this case knew or ought to have known about that mistake. Interesting little question here, which the examiner didn't raise as well. Can a machine raise mistake? There's an argument to be made, and this is off the beaten track, that contract finds it very difficult to deal with automated systems because the machine is the contracting element. It's doing what it's told to do, so it's accepting the 1599 offer.